welcome again. Last time we spoke of moving on to different planes of thought regarding what is law and how we might better consider our definitions and relationships with it. It's become quite clear, and I've mentioned it numerous times, that the law of the land regarding the British Commonwealth is explained, which means in its original Latin to lay out flat, in Magna Carta 1215. It's in language which doesn't require a sophisticated education to comprehend. Yet hardly anybody has a clear understanding of that law, and even many who do are reluctant to follow that law and uphold it. Today, I'm going to expand on the reasons for that reluctance and draw heavily upon the writings of one of the greatest philosophers of the concept of justice, Lysander Spooner. In the narration of the video of his essay on the science of justice linked in the comments box, Spooner is described as being, of all the expounders of Lockean liberalism and voluntarism, the one who has first and most articulately developed the principles to their logical conclusion, bringing the student to as clear an understanding of the concept of anarchist individualism as has ever been demonstrated. Before doing so, I'm going to quote from an exchange I had recently with someone who was attempting to justify their rejection of Magna Carta, and my response. The original question asked was for some response to why one who has spent some time explaining about Magna Carta to many people and becoming disillusioned by the apathetic and negative responses received. After pointing out that it was not so much the document itself which brought such responses, but the realization that accepting its validity carried with it responsibilities that many found too onerous or scary to take on. This fear then encouraged people to find whatever excuses they could to evade picking up these responsibilities. Whereupon a third party inserted themselves into the conversation with this, and I quote, "I've been down that rabbit hole. The 1225 Magna Carta was signed under duress and is invalid. From memory, the valid one is 1295. As you're not a signatory on the document, how can it apply to you? Australia is under Roman contract law, not British common law. Unidroit, Treaty of Rome, 1974. We live under Unidroit. Everything is contract law. What you're saying is the misinformation we were taught in school. The Magna Carta has no enforcement because you didn't sign it. It's historical. The only rights you have are created through social compact agreements in a private members association. Human rights are bylaws of the UN. The UN is a private member association. Are you a private member that their human rights apply to you? The world operates in PMA. You have unalienable rights, but they carry no weight in a trust tribunal or court. If you want a quantum leap in your legal knowledge, read Vattel's Law of Nations," end quote. I didn't know whether to guffaw with laughter or put my head in my hands and have a good groan. But I responded thus. It was off the cuff, so any common vernacular emitted is reproduced here as it occurred. Quote, "That's a pile of unadulterated tosh, my friend. I'll debunk it for you piece by piece, okay? First, Magna Carta was sealed, not signed. The monarch's seal was a representation of the authority of the Crown, which is an abstract representation of the law of the land. Monarchs are under their coronation oath, which binds them to govern according to the laws and customs of the people, who thus remain as the ultimate arbiters of the law. Coronation oaths had been in effect for centuries, since at least the time of Alfred the Great, who died in 899. Trial by jury was a system of law at that time, and as Magna Carta 1215, Articles 39 and 40 reiterated, provides for a trial by one's peers if one is accused of crimes. King John's crimes were numerous, including extortion, torture, domestic terrorism against the people, and of course murder. He was rightly tried by his peers, the barons, and given the option of obeying the law like everyone else, or being removed from office and probably exiled or executed. The requirements of the monarch were formalised in Magna Carta 1215, and while John may have been under duress, it was no different in principle than the duress experienced by any criminal when brought to account for their crimes. 2. King John chose to seal Magna Carta as a commitment binding in perpetuity upon all succeeding monarchs. It is an affirmation of constitutional law which had been existing long before, and there is no need for individuals to agree to it as a contract, as it simply reaffirms the rights and freedoms we are all born with. It is not a statute and is thus immune from repeal by any parliament or other individual or group, as is any other natural law, for example, the physical law of gravity. Natural laws may not be expunged by arbitrary acts of man. They exist in perpetuity. So the 1215 Magna Carta is the real thing, and subsequent acts of Parliament, such as the 1297 statute version, are the ones which have no validity. 3. The 1974 Unidroit Treaty is completely invalid and an act of treason committed without reference to or consent of the people by Gough Whitlam. Australia is part of the British Commonwealth and under English or British common law as affirmed at the time of the coronation oath of Queen Elizabeth II. She was constitutionally dethroned by the invocation of Article 61, by the way. 4. Every living individual comes into existence with the right to sustain and, if possible, improve their lives, so long as in doing so they don't harm or restrict the rights of any other individual to do the same. That is natural law, which is upheld by Magna Carta 1215. No group of people, no matter how large, has the right to arbitrarily impose contract law or legislation on any other individual or group. The very attempt to do so is a criminal act, as it subjects those others to the arbitrary threat of coercion, underlaid with the threat of violence for non-compliance. That is as obvious as the nose on your face, my friend. 5. Your statement that human rights are a product of the machinations of the UN or any other body of unelected representatives is so stupid as to be laughable. What? There were no human rights before the UN or private members' associations existed? Wake up to yourself. That is idiocy of the first order. 6. Legal schmeagle, my friend. The legal system is an artificial construct designed specifically to undo natural, or what some people term God's law. That is the very definition of the word in its original Latin. Legis meaning law, latum meaning made. In other words, man-made law. Made laws can be unmade, which is why one parliament cannot bind future parliaments. But constitutional law is not man-made and cannot be abrogated without consequences and always overrides legislative law. It is you who needs to learn that true power in law resides with the people via the trial by jury system, whereby juries may annul unjust legislation, a power which you can research for yourself still exists, even under the corrupt system we have now, whereby judges presume to direct juries while withholding from them the knowledge of their true powers and responsibilities. Juries, also under the lawful T by J system or trial by jury system, have the right to initiate trials for criminal malfeasance against legislators who enact legislation which harms individuals. And this trial by jury system is the only one which places control of the government in the hands of the people. 7. You have become a slave to the arbitrary power of conniving men because of your unthinking acceptance of their false, coercive legalism. A law-abiding individual does not need governing, and as such is morally bound to or justified in rejecting such arbitrary usurpations of power. Educate yourself as to the realities of law and legislation. They are totally different things, and law is supreme, not legislation. Think about it. Neither contract law nor slavery to the commands of others without consent can ever be justly imposed on anyone." End quote. Now, as one proceeds through the essay of Lysander Spooner, one will find that it touches upon these points and many others in very clear and concise detail. It is a masterpiece of composition, and I present these comments of mine only to illustrate that as ordinary people possessed of lesser talents than great thinkers such as the ones I've often quoted in these talks, we can nonetheless learn these basic principles and express them in our own voices with sincerity and without rancour, trusting that some of our fellows will recognise the inherent truths and thus be led gently to an understanding of Magna Carta and its immense importance in the world. It's no exaggeration to say that Magna Carta 1215 is arguably, indeed probably, the most important document ever produced by the human mind, because of its implications for the status of human society that may be permitted to exist if only the community in the aggregate subscribes to the principles therein. In making that claim, I'm considering that the actual economic standing of a community is not as important, at least initially, as its spiritual standing in regard to the respect each member accords to each other member. Communities can begin as subsistence cultures, and if left free to voluntarily trade products, services, and ideas with each other, can swiftly rise to levels of opulence previously undreamed of. Even with all the flaws inherent in the US Constitution and the corruption which lingered often unchecked but checked more effectively nevertheless than in other nations, the degree of freedom and individual rights enjoyed there, supported by thinkers like Spooner and others, led to a rise from the poverty levels of people living on a couple of dollars a day to unprecedented improvement in less than 150 years. How much more advanced would we be if we had not let the conniving bands of brigands, as Lysander Spooner characterises them, assume control of our organs of state to their current detestable degree? Indeed, as Spooner points out in his essay, once we understand the nature and science of the concept of justice, it becomes apparent that there really is no need for an organised central state or government at all. Just a few of his major points are: 1. It's obvious to every person, even children of the age of 2 or 3 years, when they are being treated unfairly. 2. Children understand these concepts intuitively, well before they are aware of even the meanings of the words we use to describe them. 3. People quickly learn when assembled into communities that if there are those who refuse to abide by the natural laws of non-aggression and other criminal acts like fraud and theft, that it is not only advisable to form systems to deal with and compel people to comply with such laws, but that they must do so or eventually suffer disastrous consequences. 4. The fact that such organisations may be to some degree ineffective or use methods of which an individual personally disapproves does not preclude anyone from refusing to participate in such organisations, just as they might refuse to participate or join in any other form of insurance scheme if they choose not to. There can be no right to coerce people into joining such organisations. The principles are the same. Why should people be compelled to support with taxes a judicial system which is ineffective, or a monopolistic vehicle registration/insurance scheme, any more than they are compelled to support any competitive organisation? 5. If it is accepted that there is such a concept of natural law and justice at all, and given that virtually everyone is aware of this and the principles applying thereto, and the vast majority of people abide by these laws, with only a relative few needing to be policed, what is the need for legislation either adding to or taking away from them? On the other hand, if one argues that there is no natural law or justice, then it follows there can be no crime. So what is the purpose of instituting a government at all? Why should the government organisations be able to compel people's participation? Isn't that suspiciously like the protection rackets of organised crime? When one hears the rest of the brilliantly lucid arguments of Spooner in his essay, one is left in no doubt that what currently passes for government in every nation are indeed direct descendants of those early roving bands of brigands and robbers. They are just using more sophisticated arguments to justify their predations upon the people, backed by the overt threat of force. They don't even attempt to conceal it. Their only goal is to exert an ever-increasing degree of control over those who lack the wit and the will to oppose them. I commend this essay to all. It's required reading for all listening, for anyone who cares anything at all about their freedom or the freedoms of their children. Please check out the links offered and remember the words of Thomas Paine. If there must be trouble, let it be in my time that my children may live free. Thank you for watching.